Good evening and namaskar. As we've already seen that Dr. Deepa Singh has already done one session with us, which is well received. And since she has done various sessions on different platforms in respect of the criminal law, we requested her that why not give deeper insights in respect of the new changes which the BNSS has brought in with the old CRPC in respect of trial without the accused. That point has always been evolving with the flux of time, coupled with the fact that everybody wants what is the impact of trial wherein the accused is not there. I will not take much time since we are already behind the schedule. Over to you, Dr. Deepa, and we are glad that you accepted our invite.
Thank you, Vikas. Thank you for giving me another opportunity to connect with so many participants and colleagues and friends and law students. So, as you rightly mentioned that this is a lecture series और आप ये जो constitutional का I think it's a 50th lecture. So I'll start with the constitution itself that Article 21 talks about various rights, including the right to speedy trial also. जो कि बहुत ही नेग्लेक्टेड एरिया था. हालांकि हमारी सीआरपीसी में बहुत सारे प्रोसीजरल सेफगार्ड्स दिए गए हैं अक्यूज के लिए भी और विक्टिम के लिए भी, लेकिन कहीं ना कहीं जो है वो बहुत सफिशिएंट नहीं थे, सक्षम नहीं थे. तो इस नए बीएनएसएस में एक दो नए प्रोविजन डाले हैं, बट नए प्रोविजंस को जानने से पहले पुराने प्रोविजंस को जानना बहुत जरूरी होगा. जब भी कोई ट्रायल शुरू होता है या कोई भी चार्जेस किसी व्यक्ति के खिलाफ या अक्यूज के खिलाफ लगते हैं, तो सबसे पहली चीज जो दिमाग में आती है वो आती है प्रिंसिपल ऑफ नेचुरल जस्टिस. व्हाट इज प्रिंसिपल ऑफ नेचुरल जस्टिस? वन ऑफ द इम्पॉर्टेंट principle is that no one shall be condemned unheard. So accused की presence जो है वो ट्रायल के लिए नहीं, right from the beginning और end तक उसकी presence जो है वो एक तरह से mandatory है. अगर हम पुरानी सीआरपीसी में भी देखें तो जो सेक्शन 273 पे मैं आप लोगों को याद दिलाना चाहूंगी, it says evidence to be taken in presence of accused except as otherwise expressly provided. All evidence taken in the course of the trial or other proceedings shall be taken in the presence of the accused or when his personal attendance is dispensed with, presence of his pleader. So this is the most important thing. And when I teach criminal law also, I always say that कि क्रिमिनल ट्रायल में जो अक्यूज का पोजीशन है ना वो ब्राइड ग्रूम की तरह है. जैसे ब्राइड ग्रूम की एब्सेंस में शादी नहीं हो सकती, तो हर स्टेज पे अक्यूज को होना, उसको सुनना बहुत जरूरी हो जाता है. तो नई प्रोविजन जो हम बीएनएसएस के हैं, जो 356 एक लेके आए हैं कि ट्रायल इन एब्सेंशिया, बट उससे पहले आई वुड लाइक टू डिस्कस द वेरियस स्टेप्स involved in the criminal trial, because यूजुअली बहुत सारे लॉयर्स ऐसे हैं जो स्ट्रेट वे हाई कोर्ट में शिफ्ट कर जाते हैं, ट्रायल कोर्ट में ज्यादा काम नहीं किया होता. तो अगर हम ट्रायल कोर्ट की फंक्शनिंग और उस प्रोसीजरल स्टेप्स को नहीं समझेंगे तो हम इस नए प्रोविजन को अप्रिशिएट कर ही नहीं सकते. सो आई वुड लाइक टू शेयर फ्यू स्टेप्स and I think all of you know them, but still I would like to revise your memories. So first step, we all know that for conducting an investigation or trial, what is the first step is registration of FIR, right? After the registration of FIR, the investigation starts, then the challan submitted before the Ilaka magistrate. Why I'm using this word Ilaka magistrate? Because पहले चलान को वहीं दिया जाता है, उसके बाद चलान सबमिट करने के बाद इलाका मैजिस्ट्रेट जब ये देखता है इट इज स्पेसिफिकली ट्राइबल बाय सेशन, देन वो उस केस को कमिट कर देता है. इस स्टेज को हम बोलते हैं कमिटल ऑफ ट्रायल. सो अक्यूज को हर स्टेप्स पे, राइट फ्रॉम द एफआईआर, ड्यूरिंग इन्वेस्टिगेशन, जब चार्ज पे बहस होती है तब भी हर जगह उसको प्रेजेंट होने का एक राइट है. आफ्टर दैट, देन चार्जेस फ्रेम होने के बाद जब प्रोसिक्यूशन एविडेंस स्टार्ट होता है and all the prosecution evidence is closed, then this is the most important stage in the criminal trial, that accused is to be heard अंडर सेक्शन 313, जिसको हम बोलते हैं 313 के बयान लिखाना. सो इट इज नॉट जस्ट अ mere formality like all the questions should be put to the accused. Not all the questions, it should be in the question answers form, but all the, what is important is all the incriminating evidence should be put to the accused. So, what is the purpose of trial? So that he can know the charges, he know what is the evidence, so that he can defend himself or he can prepare his defense. So this stage is very, very crucial. Section 313. If, though the accused is not under obligation to give some defense, right? Because it is for the prosecution to prove the case beyond all reasonable doubt. But still, if he has any defense, then he has to, he has been given this opportunity to defend himself and produce the defense witnesses. So once the defense witness is also examined, there is like arguments, then the stage of judgment. And I must tell you, when the date is fixed for pronouncement of judgment, it only says that whether he's been acquitted or he's convicted. So once it is acquitted, then there is no further proceedings. But if he's convicted, then again there is a one stage which becomes very, very important. Section 235 of earlier CRPC, subsection 2, he has to be heard on the quantum of sentence, why he is entitled for lesser sentence, right? So these are few stages of a criminal trial, right? And now we'll see, then there is another chapter added in the CRPC, chapter 6, जो कहता है कि process to compel appearance of the accused. Okay. Section 273 कहता है कि evidence to be taken in presence of the accused. And if the accused is not coming forward, what is the remedy available with the police? What is the remedy available with the court? So, in section 82 of earlier CRPC, it says proclamation for person absconding. So, subsection, I'm reading subsection 1. It says if any court has reason to believe, whether after taking evidence or not, that any person against whom a warrant has been issued by, or it has absconded or is concealing himself so that such warrant cannot be executed, such court may publish a written proclamation requiring him to appear at a specified place and at a specified time, not less than 30 days from the date of publishing such proclamation. And the proclamation shall be published as follows, that I'll tell you in short, that conspicuous places, so that enough publicity and enough information is to be given to the accused. Now, the subsection 4 is very, very important. It says, where a proclamation published under subsection 1 is in respect of a person accused of an offense punishable under section 302, 304, 364, 367, and so on, and such person fails to appear at the specified place and time required by the proclamation, the court may, after making such inquiry as it thinks fit, pronounce him a proclaimed offender and makes a declaration to that effect. So the section 82 talks about two persons, proclaimed person and proclaimed offender. So as you see that subsection 4 talks about when the proclamation is issued and the person is not appearing, but he is guilty of, he is wanted under these sections, then only he can be declared proclaimed offender. So now there is a slight change in the new BNSS. Otherwise, all the languages or all the subsections are same, but subsection 4 में जो specified offenses हैं, उनको हटा के ये बोल दिया गया है if the punishment is 10 years and above. So, meaning thereby, if the accused is wanted in particular section is not important, punishment is important. So 10 साल से ऊपर की सजा वाले अक्यूज को जो कोर्ट के सामने नहीं आ रहा, प्रोक्लेमेशन इशू होने के बाद भी उसको प्रोक्लेम्ड ऑफेंडर डिक्लेयर कर दिया जाएगा. So this is the first part of CRPC, old CRPC, and there are few other various provisions. For example, all of us know that personal exemption of accused can be, given by the court. So, what is that section, right? So, this is provided in section 317. 317 जिसमें हम अक्सर कोर्ट के सामने एप्लीकेशन लगाते हैं कि accused is not able to present before the court so that his personal exemption may be granted. It says at any stage of an inquiry or trial under this code, if the judge or magistrate is satisfied for reasons to be recorded that the personal attendance of the accused before the court is not necessary in the interest of justice, or that the accused persistently disturbs the proceeding in court, the judge may, if the accused is represented by a pleader, dispense with his attendance and proceed with such inquiry or trial in his absence, and may, at any subsequent stage of the proceedings, direct the personal attendance of such accused. Right. If and the subsection 2 says if the accused in any such case is not represented by a pleader, or if the judge or magistrate consider his personal attendance necessary, he may, if he thinks fit for reasons to be recorded by him, either adjourn such inquiry or trial or order that the case of such accused to be taken up or tried separately. So, as we seen, like discussed these earlier provisions of CRPC, so we can say that there were provisions that evidence can be recorded in the absence of accused also, and proceeding can also be commenced in the absence of the accused. But the new BNSS has specifically introduced a new provision, which is section 356. It says that inquiry, trial, or judgment in absentia of proclaimed offender. So before we discuss further provisions, subsections, what is absentia? Absentia means without the physical presence of the accused before the court. So as we have seen in various old sections that it is mandatory that he should be present before the court, and it is the one of the requirement of fair trial also, and basic principle of natural justice. But this section opens with non-obstantive clause. It says, notwithstanding anything contained in this Sanhita or in any other law. In any other law, मैं आपको बता दूं कि जो आपका यूएपीए है उसमें सेक्शन जो है आपका 33 सबसेक्शन 5 ऑलरेडी अलाउ करता है ट्रायल इन एब्सेंस ऑफ द अक्यूज who has absconded and whose presence cannot be secured. And in Kartar versus State of Punjab 1994, I think constitutional validity of this section was challenged, but the Honorable Supreme Court held in favor of the constitutionality. But now this section has some statutory base in the BNSS also. For the time being in force, it says first, when a person declared as a proclaimed offender, whether or not charged jointly, has absconded to evade trial, and there's no immediate prospect of arresting him, it shall be deemed to operate as a waiver of the right of such person to be present and tried in person. This is very important. First, he has to be declared as a proclaimed offender. Then it can be deemed as waiver of right of such person, and the court shall, after recording reasons in writing, so these are procedural safeguards given to the accused in the interest of justice, proceed with the trial in the like manner and with like effect as if he was present under this Sanhita and pronounce the judgment. लेकिन इसके भी बहुत सारे स्टेप्स हैं. कोर्ट हैज टू फॉलो सर्टेन प्रोसीजरल सेफगार्ड्स provided that the court shall not commence the trial unless a period of 90 days has lapsed from the date of framing of the charge. So first step, that he has to be declared proclaimed offender, and proclaimed offender, I have already mentioned that any person, any accused who is guilty of the offense or section, with there is a punishment of 10 years. Then, second, it is deemed that waiver of right, and further, after framing of charges, period of 90 days has lapsed. And further, issuance of two consecutive warrants of arrest within the interval of at least 30 days. 30 days के दो वारंट उसको जाएंगे. Published in a national or local daily newspaper, circulating in the place of its last known address of residence, requiring the proclaimed offender to appear before the court for trial, and informing him that in case he fails to appear within 30 days from the date of such publication, the trial shall commence in his absence. And further, inform his relative or friend also, if any, about the commencement of the trial, and affix information about the commencement of the trial on some conspicuous part of the house or homestead in which such person ordinarily resides, and display in the police station of the district of his last known address of residence. And subsection 3 says, where the proclaimed offender is not represented by any advocate, he shall be provided with an advocate for his defense at the expense of the state. And we all know that accused has a right to be represented by a lawyer, right? So whether he is present or not, somebody has to represent the accused, either private lawyer. If nobody is there, then the legal aid lawyer should be appointed. Where the court competent to try the case or commit for trial has examined any witness for prosecution and recorded their depositions, such depositions shall be given in evidence against such proclaimed offender on the inquiry into or in trial for the accused with which he is charged. Then, provided that if the proclaimed offender is arrested and produced or appear before the court during such trial, so the basic purpose is to secure his presence, not to punish. The purpose of the this particular section is not to punish the accused, rather stringent measures to be taken just to secure his presence before the trial court. So again, another opportunity is also given that if provided that if the proclaimed offender is arrested and produced or appear before the court during such trial, the court may, in the interest of justice, allow him to examine any evidence which may have been taken in his absence. Then subsection 5 says where a trial is related to a person under this section, the deposition and examination of the witnesses may, as far as practicable, be recorded by audio, video, electronic means, preferably mobile phone, and such recording shall be kept in such manner as the court may direct. In prosecution for offences under this Sanhita, voluntary absence of accused after the trial has commenced under subsection 1 shall not prevent continuing the trial, including the pronouncement of the judgment, even if he is arrested and produced or appear at the conclusion of such trial. And subsection 7 is also very, very important. No appeal shall lie against the judgment under this section unless the proclaimed offender present himself before the court of appeal. So, uh, okay, I'll discuss the old provisions earlier, earlier provisions after I finish this. Provided that no appeal against conviction shall lie after the expiry of 3 years from the date of the judgment, and the state may, by notification, extend the provision of this section to any absconder mentioned in subsection 1 of
She's about to join. Perchance she is exited. Yes.
Hello. Sorry, there was some again today. I'm facing lot of problem. It's okay. So the state may, by notification, extend the provision of this section to any absconder mentioned in subsection 1 of section 84. So, in short, earlier CRPC, what happened was that accused, they used to wait for the judgment of acquittal, or they used to wait for that witnesses maybe compromise हो जाए या हम उनको win over कर लें, तो वो जो है उसके बाद join कर लेते थे proceedings. One fine day they used to appear before the court, and there was a provision for filing supplementary challan 173 subsection 8, and choice was also given to them that whether they want to adopt the already recorded evidence or they want the witnesses should be examined again. And there was no provision that appeal should be filed physically, should be present before the court. And there was no limitation also for just like 3 years. And what used to happen when the accused is not acquitted by the trial court and the high court is acquitting one of the accused, maybe 10 years, 12 years, 15 years, then they suddenly appear and again join the proceedings, stayed in jail for some time, and again they are able to get the judgment of acquittal in their favor. So, two things are very, very important in this section. First, he can join anytime, and if he does not come physically, he cannot file appeal. This is very important. And if 3 years period is lapsed, then he has forfeited his right to file appeal against the conviction. So these two things are very, very important. And further, what is the corresponding change made in the BSA, Bharatiya Sakshi Adhiniyam, which used to be Indian Evidence Act 1872, section earlier section 30, now section 24. There is corresponding change in the explanation also. Section 30 says the court can consider the statement of the co-accused provided they all of them there is a joint trial. So in explanation there is corresponding change that trial in absentia will be considered as a joint trial. So it's not that if any co-accused confesses his guilt or made certain statement, that can also be taken into consideration against the accused who has been declared a proclaimed offender and he is not physically present before the court also. So further, there is a like tendency of the accused that if there are a lot of cases registered against them, they take shelter, they take asylum in the foreign countries on account of that politically इनको harass किया जा रहा है, they take asylum. But once they are like there's a proper trial and they have been convicted for the offense in their own country. So it has become, I think, easier for the government to, एक उनको वापस लाने का एक रास्ता एक वाया मीडिया जो है वो मिल जाएगा. तो इसमें जो है आई थिंक अगर हम बात करते हैं स्टेप्स की जो मेरी एप्रीहेंशंस हैं या और लॉयर्स की होती हैं जैसे देर आर लाइक 3 थिंग्स. फर्स्ट 313 statement. 313 statement accuse, it is only the accused who can provide the defense or who can rebut who can give proper valid answers of the all the incriminating evidence put to them. And again, quantum of sentence. This because 235 subsection 2 is a mandatory, it's an obligation uh, on the part of court to hear the accused on quantum of sentence. And further, where there's a presumption of, or there is a presumed that culpability is presumed, or there is a burden of proof lies on the accused, not on the prosecution. So there are many, questions, and whether it is, valid also to forfeit his right of appeal. जो कि हम जब appeal पढ़ते हैं तो कहते हैं कि appeal is the creation of statute and first appeal has to be admitted as a matter of right. So these are particular questions, and I think I tried to cover because the topic was very short, trial in absentia. So, but again, if I'm open to questions and maybe I'll invite certain queries. So,
Today, a lot of lawyers from Punjab Haryana High Court have joined.
okay,
Raghujeet Madan has also joined. I will ask
okay.
to share his insights.
Because it's a new provision, so I think अभी जब तक कोर्ट, हाई कोर्ट और सुप्रीम कोर्ट से कुछ डस्ट क्लियर नहीं होती ना, तब तक कुछ डिबेट आती भी नहीं। अभी आई थिंक अभी ये यूज भी इतना नहीं हुआ होगा,
Yeah.
बट फिर भी क्वेरीज तो एनी क्वेश्चंस?
I'm just checking it out, but meanwhile, I've asked Sonia Madan and Raghujeet to unmute if they can. One question is, though you have told about, what specific safeguard does BNSS introduce to prevent the misuse of the trials conducted in accused absentia?
I think I have
No, carried it out, but
yeah.
but it is
First,
basically
okay.
one can understand in the gist.
Yes. First of all, there is a proclamation against that person. Enough time has been given to the accused. During that period, once the proclamation is there, he can always come and join the proceedings. Then after framing of charges, there is a provision for 2 consecutive warrants, conspicuous places. There's obligation to inform his friends and relatives also. So if he is not coming and the court has waited enough, then it is deemed that he has waived off his right. And further, if any evidence is collected or if he joins, he can always has the right to examine that evidence. But for that, he need to come. He need to be present. As I told, and I think it mentioned also, these provision is not, purpose of these provision is not to punish the accused. It's just that we want to secure his presence. And I think earlier CRPC was more accused oriented. This BNSS is, I think, victim oriented. So at least victim in most of the cases, a case is registered, accused is not joined proceedings, declared proclaimed offender, and he does not get any, he or she does not get anything. At least he or she has this satisfaction that trial is taking place and he's being convicted. And if he or she does not appear, at least he'll be losing his most important right to file appeal against the conviction also.
And the next question is, how does BNSS ensure effective communication to the accused regarding the trial dates and notices when the trial proceeds in absentia?
Tanu asked.
Tanu is there?
Okay.
No, I'm just checking it out.
Okay.
Whether
No,
Tanu...
I think I just presume that it must be her question. So it is subsection 2 says that issuance of 2 consecutive warrants of arrest published in a national or local daily newspaper circulating in the place of his last known address of residence, and inform his relative or friends, affix information about the commencement of the trial on some conspicuous part of the house or homestead in which such person ordinarily resides, and display in the police station of the district of his last known address of residence. And further, if he is not represented by any lawyer, he shall be provided with an advocate for his defense at the expense of the state. And again, doors are still open. He can always come anytime and join the proceedings.
And the last question is there any distinction drawn in the law and the statute where the accused deliberately absconds or where he was unaware of the trial?
For that, he need to first challenge that order of the proclamation, right? If has the courts have enough power to quash these orders, if he is able to convince the court that reasons beyond his control or whatever. So we see in routine that accuses mm, apply for quashing of such proclamation on these various grounds.
The last question is, this is by Priyanka. What are the court duties regarding appointing of defense counsel for the absent accused? Can the absent accused object to the appointed counsel later on?
I think this particular provision is silent about this, that he can challenge, but he can always, where a trial is, he can always challenge the deposition and examination of witnesses.
Thank you. Just what we were saying. Kritika ends up with saying, thank you so much for the insightful session, ma'am. Could you kindly also clarify what happens if the absconder is convicted? Is the sentence immediately executable, and how does the state legally enforce it once the person is abroad?
So I think once he's convicted, first, so if he's in a foreign country, so we need to take that whether we have that treaty with that foreign country, and it is just not possible to execute, right, if he's not present. But the consequences attached after the conviction is very, very higher because of two provisions. If he wants to file appeal, he has to be physically present. He cannot file appeal through, lawyer. And once the 3 years period lapsed, he cannot file appeal at all.
So thank you, Dr. Deepa, and all those who have joined us on this session. And we are glad that everybody has well received this session. And those who have missed the earlier sessions, including by Dr. Deepa, the previous one, can subscribe as well as watch sessions on Beyond Law CLC. Thank you, everyone. Stay safe and happy Sunday again.
Thank you, Vikas.